Joel Brodsky joins me now. Joel, thank you so much for joining us. First and foremost, your reaction to all the proceedings today, and then the judge's ruling. Your next hearing is in April. Are you breaking the law by coming on air tonight?
No, and Judge Carlson, if you watch the video, I'm not talking about my representation of Drew Peterson. I'm not talking about anything. So, I mean, Judge Dave Carlson, I've gotten in a lot of trouble. I've been very critical of the judiciary in Cook County, especially. Judge Carlson is one of the good judges. And if he requests that I don't do anything for a month, says don't talk about your representation, I'll honor that. I have that much respect for the man. He's a good judge.
I do, I don't want to interrupt, but I do understand you're abiding by attorney-client privilege and that you respect the judge. But if we were just speaking hypothetically, because you have gone on so many news networks and said basically that you do have information that would help a family, a grieving family, that hypothetically you do have closure for a family. What do you have to lose? I mean, is it the gag order that you're afraid of? I mean, why not?
Couple of months in jail, but look at when people talk about this post-conviction hearing ending in some sort of new trial, it's a fantasy. Drew's, the fact of his claim of ineffective assistance of counsel has been rejected by 12 different judges, a dozen, you can count them. In the appellate court, Supreme Court, trial court, federal court. They've all been rejected. It's a fantasy. So there is zero chance.
Well, I mean, sir, I have to interrupt you. Fantasies can become realities. It's not out of the question, is it?
Well, when I was practicing, I did a number of these post-conviction cases, and I can tell you that 99% of them end up being dismissed on motions because they don't bring up anything new. The post-conviction petition is to bring up something new that wasn't known at the time of trial and wasn't of a constitutional magnitude, like a cop denies beating a guy into a confession, and later on, after the man's in jail, comes out that the cop was a serial, abuser and coerced confessions out of a number of people, and he was lying on the stand. That's what a post-conviction petition is for. It's not a second bite or third bite or fourth bite at the apple. And that's, it's wrong to say that. And I think that when people say things like that, it's opening up old wounds for the families. They want closure, they want finality. Drew's had his case reviewed by, a dozen judges. So it's just a fantasy. This whole thing about his competency is a fantasy.
Sir, aren't you opening up new wounds for the family? You're the one who said that you may have information to help them find their long-lost sister.
If I could, if I was allowed to do it, I said I was thinking about doing it, not that I was going to do it.
Well, what's
by the way,
stopping you?
The attorney-client privilege and the gag order. I believe that there should be an exception to the attorney-client privilege, and I wrote an op-ed about this. That in a certain circumstance where a man has exhausted his remedies on appeal and he's not going to get out of jail, and that there's a missing person situation or some situation where somebody needs closure that's unknown, it's not going to do any harm to the client. I mean, to the former client. He's in jail for life. Why shouldn't the attorney be able to bring closure to the family if he chooses to do so? I think there's a lot of exceptions to attorney-client privilege. I mean, Trump's lawyers just testified for a grand jury about their attorney-client relationship.
I do have a question for you. So let's just say hypothetically, because I read your editorial and I can hear your arguments. You said it was for the family. You said it's not about money. So if it's not about money, and maybe you're thinking about it, why not go down to the police station and say, this is what I know. I don't want publicity. I don't want money. I want to help this family.
That would be a breach of the attorney-client privilege and a breach of the gag order. And it would be also, at this point, would be disrespecting Judge Carlson, which I have no desire to do. But I mean, what you have to understand, what's very strange here is this. What you have to understand is this. This whole thing about a competency exam. It makes no difference what Peterson's competency is now. His competency at the time of trial is what's relevant. This is a a canard. It's a red herring. It's meaningless. You don't. A person doesn't have to be confident to have a post-conviction case go forward or to have it dismissed. It's irrelevant completely. This is just another red herring. You have to remember, this post-conviction petition has been pending, and Judge Carlson, this is not talking about my representation. It's post-conviction petition. They usually over 18 months. They rarely get that long. This one's going on 2.5 years. The public defender still has not amended through his handwritten pro se post-conviction petition that he scribbled out and filed. The state's attorney has had a motion to dismiss on file for over 2 years and hasn't sought to have it heard. Why are they dragging this thing out with ridiculous, mental health exams? It makes no sense at all. There's something going on behind the scenes here, and I don't even think Judge Carlson understands what's going on. But to see the state's attorney agree to continuance after continuance after continuance after continuance, and the families have to hear on television that, Drew Peterson has a hearing for a new, maybe he'll get a new trial. It's got to be devastating to them.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.